post 1993, the second judge's case, which ironically you appeared and won.
That's right.
That resulted in the Collegium system coming in place and judges appointing their own. Judges appointing fellow judges.
That's right.
The government in 2015 brought the the NJAC bill and decided that this
but
bill...
it was not the Venkatachalaya bill.
It was not the Venkatachalaya bill. That's an important distinction you're making.
Yeah.
But it was a bill that would, in a way, take away some of those powers of the judges to become the sole arbiters of who becomes a judge.
Yeah.
That was struck down in the Supreme Court on the grounds of the basic structure doctrine being affected.
Yes, but why?
Now the government is saying we want to go back to it.
Yes, but you must know why this basic structure. It's not a mantra, not the basic structure mantra. It is because, contrary to what Venkatachalaya had suggested, this was a scheme of six members of a commission, with two non-lawyer, non-judges who would have an overriding veto over judges' suggestions. That was the crux of the matter. That was the crux of this National Judicial Commission. Otherwise, I think that the judges would probably welcome this if you had a commission as Venkatachalaya had suggested.
In fact, some of the judges in the NJAC judgment itself said, yes, the Collegium system needs reform.
Of course it does.
And you believe it does need reform.
Of course.
You should have appointees of the government along with the three senior-most judges.
I'll tell you, Lord Cook, who was a distinguished judge from New Zealand, he was the only judge to be appointed in the House of Lords, in England also. When he was asked to give a lecture here, the title of his lecture was "Where Angels Fear to Tread," and the first line of that is "Fools march in where angels fear to tread." So that was the suggestion. I mean, he therefore made a very deft title.
You know, we have reached a stage, though, where there seems to be mistrust at the moment between the executive and the judiciary.
But you see, I don't know, Rajdeep, if you read Chagla's memoirs,
yes,
and he was one of, in my view, the most distinguished judges ever was there in the country from 1950.
M.C. Chagla.
M.C. Chagla, outstanding. Now, he writes and he said that he was not very fond of Mr. Morarji Desai, who was the chief minister, nor did their habits concur. But in any view of the matter, every month they'd meet each other at one place or another, either in the Chief Justice's house or in the Chief Minister's bungalow in Bombay, and discuss, because there's a lot to discuss, not merely judges. There's a lot to discuss about where the head of a judiciary and the head of the executive between them. I don't see why there can't be this camaraderie and this one-to-one without the press, without the media, without everybody being there.
Are you saying that the way out, therefore, is either the Prime Minister and the Chief Justice meet regularly, or the Law Minister and the Chief Justice meet regularly, behind closed doors, not by throwing muck at each other, or certainly not by the executive suggesting, for example, as Mr. Rejuju only yesterday has, the Law Minister says judges are not elected.
Oh, we've heard that before.
And therefore, because they are not elected, in a way questioning whether they can dictate terms to Parliament, which is elected.
You see, elected judges, I mean, America is the finest example of, because they have a mix. The state judges are elected.
Yes.
The federal judges are not.
Yes.
And they are appointed for life. And you see the difference. They themselves will tell you that and they are weaning away from the election system totally, because it just doesn't work.